Hi, my name is Aaron Fontana, and I'm a criminal defense attorney with the Kann California Defense Group. Today, I'm going to talk about the crime of being drunk in public, also known as public intoxication. Under California Penal Code 647F, the prosecution must prove the following elements in order for one to be convicted of public intoxication. 1, that you were willfully under the influence of alcohol, drugs, or some other controlled substance. 2, that you were in a public area. 3, that you were either so intoxicated that you were unable to take care of the safety of yourself or others, or that you were obstructing a roadway, a walkway, or some other public pathway that others walk upon. Let's break down some of these elements. First of all, willful intoxication. To do something willful, it means you have done it intentionally. Usually people become intoxicated on their own free will. They go to the bar, they have a drink, or they take some drugs on their own. However, there are cases where someone has been slipped a drug while in a bar, or someone has added alcohol to their otherwise non-alcoholic drink. In such a case, when the intoxication was not willful but perhaps imposed by another person, then public intoxication would not apply as a charge. With regard to the element of a public place is an area outside your home where strangers are free to walk around. Examples of this are restaurants, bars, barbershops, shopping malls, etc. But there's a little more to this than would meet the eye. California courts have also held that the inside of a car that's parked on a public road is public. Also, the hallways of hotels and apartment complexes are considered public. Additionally, courts have held that the area outside your house, such as your front lawn, could be considered public. But no, you cannot be arrested in your home or in your backyard, your shed or garage for being intoxicated. So with regard to the element of being unable to take care of the safety of yourself or others, this basically means that you would be so intoxicated that you would either potentially cause harm to yourself or another person who's nearby. An example of this is, say there's a person named Charlotte, and she's at a Dodgers game, and she's a big Dodgers fan. She's also currently very intoxicated, and she's angry because her team's losing. Charlotte's standing at a railing in the stadium, and 25 feet below her are other fans watching the game. Charlotte's so angry that she's yelling at the umpire, and she's occasionally losing her stability, making it so that she's almost going to fall or will fall, not only potentially hurting herself, but the fans below. In such a case, she's clearly unable to take care of herself and others, and she would likely be guilty of public intoxication. With regard to the element of obstructing the use of a public way, an example of this is a man who was so drunk that he just laid down in a street, and this caused a backup with the cars. In such a case, he would obviously be so intoxicated that he could be found guilty of public intoxication. The penalties for public intoxication are as follows. Penal Code 647F is a misdemeanor that carries up to 6 months in jail and a $1,000 fine. If you're convicted of it 3 times in a period of 12 months, however, there would be a minimum punishment of 90 days in jail or 60 days of rehab. Here are some defenses to public intoxication. First, you were not intoxicated, or you're not intoxicated enough to be guilty of the crime. One can be intoxicated, but at the same time not be a danger to themselves or others, or unable to take care of the safety of themselves or others. In such a case, you may be able to avoid the public intoxication charge. Another defense would be that you were not in a public place. For example, the police arrest you at a house party, they could not charge you with a public intoxication. Also, police couldn't find you in a private place and then move you into a public place and try to charge you with public intoxication. Another defense would be that the police violated your civil rights in that there was no probable cause to arrest you for public intoxication. Police can't just see that you're drunk and hand you a ticket for public intoxication. There has to be at least some reasonable suspicion that the police can point to show that not only are you intoxicated, but that the other elements of the crime exist there as well. In such a case, where probable cause may not exist, a good California defense attorney would file a motion to suppress the evidence in the matter, and if it was granted, the case would be dismissed. Another way that the Kann California Defense Group has been successful in defending such cases is working with the prosecutor and the client to have an informal diversion where the client perhaps does some punishment, such as meetings of Alcoholics Anonymous, comes back a little while later, and the prosecutor, instead of going forth with the charges, just dismisses them. If you or someone you care about has been charged with public intoxication, give us a call at the Kann California Defense Group, and we can talk about the possibility of having your charges reduced or dismissed.